that if I picked your email and shared it without your consent, then I'll be liable. So even how do you even store the said data? In our profession, when we hiring, whether we are consultants or we are working for our employees, there are different ways that we store data. And I think we collect very, very sensitive data on our end, including not just the employees, but we also collect for their dependents. So today, we are partnering with Netcheria International. And I think of all the data protections trainings I've attended or I've listened to, I found them to be the most reasonable. And I'm sure the 300 of us today, when we live here, we will live better than we found. And they will ask the questions: have you registered your employer? Have you started providing information as requested by the Commission? Are you seeking consent before you share that data? If you share without consent, what are the consequences? And if you want to get consent, how are you going to do it? So Netcheria team are here with us to demystify in a language that we can understand, the language that I want to call the HR language. Thank you, and happy learning. And I know just few hours is not enough to learn this. We will have lined up trainings on data protection, the laws and how it affects us, and how we can continue implementing. So karibuni, and allow me now to hand back to Milka so that she can invite our facilitators for today so that they can demystify this thing called data protection and how it impacts us as HR professionals. Asante sana, Milka.
Thank you so much, Edie. Can we clap for Edie? I know we can clap. I want to see your clap. Yes, let's clap for Edie. It's going fast. Let's clap for Executive Director for that wonderful opening remarks. Are there claps?
Thank you. I can see them.
So
Thank you.
You can see the clap. That's good. Thank you so much. Thank you. And I'm being reminded to inform you that we are also live on YouTube. So if you're not able, maybe if your colleague is not able to join this webinar, they can log in to our YouTube. So because it's free, so we are online there. So thank you so much, our director, for that opening remarks. And yes, organization increase reliance on technology to manage every aspect of the business affairs that requires to rethink what personal data is shared, where, when, and with whom to share that data. The organization may build walls to protect data, but those walls cannot guarantee solid security. So that's why HRM today is in partnership, has partnered with the Netcheria to take us through this Data Protection Act. Though, as Didi said, time might not allow us to cover everything, but I believe the 2 hours that will be here, will have learned something. So we have 2 speakers today. We have Georgia Manyara Waroiru. George is a lawyer specializing in tax law and corporate commercial law with a specialization in data protection law and compliance. The other speaker is Maurice. The extensive background
I think we've lost Milka. Can you hear me? Good, thank you. As Milka tries to sign in back, yes, Milka, welcome back.
Right. Thank you so much. No, I found myself out. Thank you so much, Edie. Yes, I was introducing Maurice. Maurice is a corporate and commercial lawyer with extensive background in data protection and privacy compliance. He's well versed with the legal framework relating to data protection and the implication of the same, and regularly advises clients in compliance matters. He also has experience in regards to matters relating to media and telecommunication law, as well as financial services and fintech. So these two speakers, as you can see their profile, they are well versed with the data protection, and they're going to take us through this. So karibuni sana George and Maurice, and not forgetting Rachel. For questions only. Then we can use the chat box for any other thing so that we don't mix up questions and with comments. I hope we are clear up to there. So thank you so much. Karibuni sana Maurice and George. We are sorry for some technical error, but we are working on it. So George and Maurice, karibuni sana. Thank you. George, are you there? Maurice, are you there?
Hi, Milka. Sorry about that. I think there was a slight connection issue, but we're back on. Thank you very much for the introduction.
Aha, okay. Karibu sana.
Thank you. Thank you so much for the pleasant introduction and welcoming us to be able to speak to you about data protection and just demystifying and breaking it down into maybe small edible pieces. As you mentioned, it might not be possible to go over every single detail about, but what we can do, we can try go over the main concept, the main principle that are what we call data protection. And then from then on, we can have other sessions just to break it down piece by piece. Well, I think to begin with, I'll start talking about the general principles of data protection, what it entails, what's captured under it, especially for HR professionals, especially in regard to all the technology that we use in our day-to-day to handle the operations of our business and our personnel. Then after breaking it down from the definitions, the principles and everything, then we'll walk through how lawful processing of personal data is considered under law. So what does that mean when? You can be heard. Can you hear me? Can anyone hear me?
Yes,
Maurice.
I can hear you. So I believe
yes, you're breaking just a bit.
Yes, I can hear you. Okay.
Can you hear me?
Yes, I can hear you. Yes, I can see from the chat box. Yes. Participants can hear you.
Yeah. Proceed.
Yes, but poor connection. Okay. I can see that.
Right. Okay. I can see a number of you can actually hear me, so I'll just proceed. As I mentioned, this will just be, at least the main aspect would be to break down what data protection means, what the laws say about it, and maybe just bring about the concepts that have been introduced by the law. Who's supposed to register? Who's a data controller? Who's a data processor? Who's a data subject? What does it mean when you're saying we're processing personal data? So the whole goal of today is capture all these new aspects that have been brought to life, see how we can relate them into our day-to-day activities, then go over the principles of data protection as captured under law, and also cover what it entails to process data in a lawful manner. Following that, we may capture maybe just a few other aspects that have been introduced by the Act. And that's in terms of maybe some obligations and requirements if you're holding personal data, in which as HR professionals, we are holding a lot of personal data. So I'll go over some obligations that were required, maybe some obligations regarding to undertaking some assessments if necessary, whatnot. We'll then very briefly look at the regulations and what they bring to light, which my colleague will assist with. And following that, we'll just wrap it up and tie it all in. And then maybe we can take a few questions. Feel free to ask us or to throw any questions if you have in the chat box or in the Q&A during this time. Thank you so much. George will take us through the beginning of at least the first bit of it, where we're talking about the core elements and core principles of data protection.
Yes, good morning, everyone. It's so good to be here on this wonderful day where we are learning about data protection, and we are going to demystify what is data protection for HR practitioners. So as I've already been introduced, my name is George Manyara, and I'm an associate at Nigeria International. So the first question that we need to ask ourselves is, what is data protection? And before we even go to the definition, we need to ask ourselves, in the internet age, what is the most valuable asset that we have in the modern world? It is privacy. So with the ambit of the data protection, we asked ourselves a very, very important question. Is our data secure? And now, because all practitioners, all HR practitioners and all other individuals who handle personal data, they have to be in compliance with all the data protection laws, not just in Kenya, but also globally. And considering that this is a constitutional mandate, that is the importance of data protection as a whole. So in definition, what is data protection? It is the legal mechanism that ensures privacy of personal data. So there are two aspects that we need to understand here. There is privacy and there is personal data. So privacy, the right to privacy, as provided for under the Constitution of Kenya, Article 31, provides that all information that is provided by all individuals has to be private, and it should not be disseminated. It should not be forwarded to third parties without consent. So that brings a very important point, consent. When we are talking about consent, it means that the person who is giving their personal information, could be their name, their KRA PIN, their email address, their phone number, so on and so on and so forth, they have to give their consent. That is that's the premise of Article 31 of the Constitution. Now, when we move on to the next aspect of the definition, which is personal data, as I have already mentioned, personal data is data that relates to a specific individual that is only designated for that individual. The same way each human being has a specific genetic makeup, has a specific fingerprint. It is the same way each individual has a name, has a phone number, has an email address, a health status, or even mental status. And just to bring it home, for HR practitioners, it is information that is specific to HR, to persons who are working in the HR field. This could be employers, could be employees. That's a point to note. So now when we move on to the key terms in data protection, there is a data subject. And a data subject is defined as an identified or identifiable natural person who is the subject of personal data. So the question that we have been asked, and I have been asked personally, is, can an organization be considered as a data subject? Now the answer is no. A data subject is only a natural person, meaning that it's a human being, and you can only collect specific information such as KRA pins, the name, the ID from a human being. What is personal data? Personal data is any information that relates to an identified or unidentifiable natural person. So this is specific information that comes from the data subject. Now you get the flow. We proceed now to the third one. Sensitive personal data. This is data revealing the natural person's race, health status, ethnic social origin, the conscience, belief, genetic data, biometric data, property details, matrimonial status, family details, including the names of persons, of the person's children, parents, or spouse, the sex of the data subject. So now you've seen the flow. There comes from the data subject, who and the data subject. Up to there, that is the fundamental principle. That is those are the fundamental terms that we need to understand when we talk about data protection. So now this raises another question. After I've already discussed who is a data subject, what is sensitive personal data, and what is personal data, we move on to what is data processing. Now, data processing is any operations performed on personal data. Note this, any operations that are performed on personal data. So it means the data was already collected. So this data is now being processed, and it is processed in the form of collection, recording, organization, and structuring. This data, this personal data, can also be stored, adapted, or altered in any way to fit the needs of the data holder or the data handler. There is also the retrieval, the consultation or use of that personal data. There is a disclosure by either transmission, dissemination, or otherwise making available, or alignment or combination, or restriction, erasure, or destruction of the personal data. That encompasses what data processing is all about. It is simply the processing, the operationalization of this personal data. You have already received the personal data. Now you're working on it. Yeah. So we can proceed to the next slide on data controllers. Maurice, you can proceed. Yes. So now there are other important terms that we need to understand here. Who is a data controller and who is a data processor? As per the Act, as per the Data Protection Act, a data controller is defined as a person who determines the purpose and the means of processing of personal data. This means this is the individual who takes part in the collection of the personal data and determines how this personal data will be processed. What is its purpose? You cannot collect any information just for the sake of collecting information. It has to be collected for a specific purpose. In this case, in this forum, all HR practitioners, they collect personal data. It could be for purposes of processing our payroll. Just to give an example, that there has to be an intention for the collection of any personal data. So that raises another issue. If there is an individual who's collecting my personal data, then who is going to work on my personal data? As per, if you remember our definition of data processing, there has to be another individual who is known as a data processor. Now, this data processor is a person who processes the personal data on behalf of the data controller. The controller in this case, whereas they're determining the purpose and the means of processing the personal data, there is another individual, the data processor, who processes the personal data. So now the HR practitioner, there, you receive the personal data, the name, the KRA PIN, the email address, the phone number, so on and so forth. You process it for purposes of a payroll, including bank details. Yes, you collect bank details. That could be for purposes of processing the payroll. So you need to note this. These two individuals, the data controller and the data processor, they have to be registered under the office of the Data Protection Commissioner. And the registration process of the data processors and the data controllers, it commenced some months ago in the month of July. And the commissioner is yet to set the threshold for registration. So this is still an ongoing process, and it means that all individuals who are processing personal data or they're controlling personal data, they have to be registered. Yeah, we can proceed to the next one. Okay, we are now at a very important individual in an organization, and this is the data protection officer, or better yet, a DPO. So who is a DPO in this instance? A DPO a DPO can either be a data controller or a data processor as per our definitions. So the DPO is appointed where the processing is carried out by a public body or a private body, where there will be regular or systematic formatting of data subjects. This means the natural persons, and the processing consists of processing of sensitive personal data. So does it mean that each and every organization has to hire a new individual to be a data protection officer? That's not necessary. This post can be held by a member of staff, and they may fulfill other duties so long as there is no conflict of interest. And they have to meet the threshold that is provided for under the Data Protection Act. So this means that they can either be a lawyer, they can either be an IT specialist, so on and so forth. And they need to have the knowledge and the technical know-how in matters relating to data protection. So when you look at a data protection officer, this is a key individual in each and every organization that handles personal data, because they are collecting the personal data, they are processing the personal data. Yeah. So each individual has to be, each organization has to register a data protection officer, and a data protection officer can handle either role. There are normal roles, and they can also handle the role of a DPO. Okay, Maurice, you can proceed. So finally, what are the duties of a data protection officer? They are to advise the data controller and the data processor and their employees on data processing requirements under the Data Protection Act and any other written law. And remember that the fundamental principle that cuts across data protection is privacy. So they have to make sure that all information that is collected and processed is handled for the benefit of privacy of those individuals, of those data subjects. There is also the issue of compliance of the Act. The Act requires for registration. The Act also requires for maintaining the rights, for maintaining and enforcing the rights of all data subjects. And it also provides a mechanism for complaints handling and procedures. Yeah. There is also the aspect of facilitating the capacity building of staff involved in data processing operations, and providing advice on data protection impact assessment and the cooperation with the data commissioner. So this raises a really important issue on the data protection impact assessment. Does it mean that as a HR practitioner, that the ball stops by just simple registration? No, it doesn't. You have to make sure that all your policies, even your HR manual has to be in line with the Data Protection Act. All personal information, there has to be a surety that all information that is collected has to be safe, has to be stored safely, and has to be secure, and will not be transferred to third parties without consent, though there are exceptions that shall be covered later on. So what are the rights of a data subject? A data subject has a right to be informed of the use to which their personal data is to be put, to assess their personal data in the custody of the data controller and the data processor, to object to the processing of all or part of their personal data, to correct any false or misleading data. There are individuals who may give data that is wrong or that is misleading. So it is their obligation to make sure that the data that is collected is correct. And there is also the deletion of that misleading personal data. So the key thing that we need to understand here is privacy is everything for the data subject. I need to make sure that my information, that the information of 50 million Kenyans is secure. So all HR practitioners have to endeavor to make sure that the information they collect, the personal data that they collect from data subjects, is stored safely, it is processed for the right purpose, and it is controlled in such a way that it will not disseminate to third parties without the consent of the data subject. From my end, that will be all, but we shall be taking questions afterwards. Now, I leave it now to Maurice to take over. Thank you.
Thank you so much, George, for that really comprehensive introduction to data protection and just covering the basics in terms of the roles of a data protection officer. Who are they? What do they do in an organization? And then going back to the foundation, who is our data controller? Who's a data processor? What's the difference between the two? Those are very key fundamental bits that we'd be seeing across all aspects of data protection, even as we cover how to process data in line with the law or the obligations under the law. You'll see there are different obligations assigned to each person and different responsibilities and rights for each other individual. Now, as we had very broad, it almost captures anything that you do. From the point of collection, you're already processing data. So as long as you're handling data in one or another, you're processing data, and it needs to be done in line with the law. As wide as it is, we'll still break it down and work with it. So just to start with, in terms of what do you mean by saying make sure you're in compliance with the law? The Data Protection Act was enacted in late 2019. And it has come up until 2020. That's when you have regulations that are actually being used to assist in enforcing them. But just to have a nutshell of the main objects of the Act is the 8 principles of data protection. I'd want to just add that these principles of data protection, they're not just reflected in our law, but these are actually international principles of data protection, right? And you can see how it relates in our everyday life and everything that we do. So to start with the first principle is the principle of lawfulness, fairness, and transparency. This is, in a nutshell, ensuring that your processing is done in a fair and lawful way. Lawful being compliant with the law, just a small aspect as make sure there's consent, make sure it's done in a transparent manner. Make sure that would mean make sure the person or the data subjects, or rather the employees or personnel that you're handling the information, they know you have the information, they know what you're doing with it, and they know how it's being processed from start to finish. Just transparency, make sure that they know how in everything that's being done with the law, and just making sure there's consent to it. Consent is a very, very key aspect that would end up popping up everywhere we see. Make sure there's consent in processing, in doing this, in doing that. So that's one of the very key principles of data protection. Second one is of purpose limitation. This principle essentially says that you're only supposed to collect or rather process personal data for its intended purpose and nothing else. What does this mean? This means, for instance, you're collecting information for purposes of payroll or for what's called assessment of any nature, or rather even recruitment or whatever purposes. That one purpose or that very specific group of purposes that you have mentioned, or rather informed the data subject that you're collecting the information for this reason, you're only allowed to process it for that specific purpose. even if you have the information and you want to process it in another way, for instance, undertake another study or being able to analyze it in a very specific process, you still have to go back and ask the data subjects, the personnel that get the consent that we're about to do this with your information, just so that they can also give consent to that other processing. Because I've only consented to one, the one you told them, we're taking this information for payroll, and that's what you're only allowed to do. When you have another purpose that you want to achieve, you have to go back and seek consent to it. That's the purpose limitation. The third one is data minimization. And this basically it's basically the principle that should only collect what is needed, nothing else or nothing more than that. So if you're collecting this pool of information for a specific form of review or assessment or study, that should be, you only collect information that is necessary to it. For instance, maybe if you could, George has used the word payroll. If you're using it for payroll purposes, you don't need information relating to, for instance, family or biometrics in regard to that person. That has nothing to do with it, so you should collect. You only collect what you need for that purpose, nothing more than that. The fourth one is the principle of accuracy. This is a bit more straightforward. It's just making sure the information that you collect and process is accurate and up to date. This would mean also having in place some mechanism where the data subjects, the personnel, the employees, or any other persons are able to update this information if it changes in one or another. So if it was for possibly reasons of providing benefits and whatnot, they can come and update the information of, yes, now I'm married, or I have these children, or my address has changed for X, Y, Z. So there should be some system in place to allow the data subjects, the personnel, to be able to update this information if need be. But our job is just to make sure it's as accurate as possible. The fifth one is the principle of storage limitation. This one, basically, it requires that you do not keep any personal data longer than you need. This is majority in fit in terms of our professionals, HR professionals. This would mostly be very important in terms of retention of information. So what happens when you collect information for someone joining an organization and whatnot, and you process it through their time of employment, and then they leave? At what point do you get rid of the information that you're holding of previous personnel or previous staff who've already left the organization? As we've just mentioned before, you only use the information for a specific purpose and only what is needed. Meaning, when you don't need that information, then you shouldn't have it. You should either dispose of it or return it to the specific person, if it's physical in any kind of way. So there's no specific, at least under law, there's no specific timeline whereby you need to keep information. Should you keep it 6 months after they leave, 1 year after they leave, 2 years after they leave? What it says, it should only be kept for a period that is reasonable. What does that mean? That would mean, look at in terms of whatever the use of the information is, or in terms of the organization, what are the policies, what are the principles? If you need this information for the next 3 years, what do you have to justify that? What do you need that information? Why do you need it for that period of time? So if you can be able to justify it, yes, we need it for maybe a bit of tax reasons, or maybe any marketing skills or anything, as long as it's you've been able to justify why you're retaining that information for that period of time, then that would be fine. If not, the information should either be returned to the specific data subject, that is, if it's physical information, or just destroyed or deleted from the systems. Yes, that means that you cannot hold someone's information for 20 years, even if they were in the organization. There's absolutely no reason to hold the information if all uses of it that are reasonable and under law have been accomplished. Then this does not need to be in your systems. The sixth one is the right to privacy, which one has been discussed at least by my colleague George in terms of the right to privacy under the Constitution. It's just taking into account people's right to privacy, as is making sure their family life is protected, making sure you're not interfering with their personal life, or rather anything that does not have or any relations or connection to the particular purpose that you're doing, that you're using the information for. The right to privacy is, fairly straightforward and stands under our Constitution. The next one is the accountability principle. This is basically one that requires integrity and confidentiality. This means the information that you hold, the personal data you're collecting and processing, all the information in regard to your organizations needs to be kept safe and secure. This may require you to have some systems in place, maybe some cybersecurity measures in place to make sure you have such information safe, or any other measures previously there has been, before the digitization, you just store information in files and keep them covered and whatnot, which would not be the case at the moment, especially with all the improved technology where someone can easily access this information. So yes, make sure it's safe, have cybersecurity measures, have all this antivirus and firewalls. Also, above that, make sure you're limiting the number of people who can access this information. As HR practitioners, the information I collect and process and you store, it's not for everyone's eyes, maybe for management, maybe for the organization's purposes. This is not for all other employees to be able to see who information other. That's something you also need to take into consideration. The last one is the non-transferability principle. This basically entails that you're not allowed to transfer any personal data outside Kenya. That is the rule of thumb in general law right now. However, there are very specific instances where you are able, or rather allowed, to transfer the personal data outside Kenya. One, there has to be explicit and express consent that the data subject has allowed you to be able to transfer this data. Of course, this would mean all other principles come to play. Tell them why it needs to transfer it, why you need the information transferred. Make sure it's a very transparent process as you tell them, as you show that, as you move the information. Make sure it's safe. Make sure this information won't be intercepted or hacked for some other reason. And also make sure that you have the appropriate safeguards in place to be able to keep the information safe. So the general rule is you're not allowed to transfer information, but if you do, consent, safeguards. And in some instances where you're transferring huge and very large volumes of data, you might also need the approval of the data commissioner. That's just something to think about. So these principles are what we're going to cover throughout when we're discussing lawful processing of personal data. It'll one or another just touch on them, that you can be able to see what we mean by lawful processing of personal data. So maybe you can even just jump right into it. Personal data should only be processed, as we said, lawfully with the consent of the data subject. Consent here refers to not just plain consent. It should be express, explicit, and well-informed. This basically means whatever they're consenting to, if they're consenting to collecting the information for reason X and Y, Z, this would mean that they should know this is what we are consenting to. It shouldn't be, for instance, something they're just signing where they're not aware. They should know exactly what it is, and it should be very clear that they're giving consent to the processing. So either by signature or a checkbox, it just needs to be very expressly clear, not something that you can hide in between the lines. Usually that's why a lot of our contracts, you sign at the end, somewhere where it's almost a separate page so they can clearly see you've consented. It wasn't something they did by mistake. Second one is for the purpose of entering into or performance of a contract. Possibly in our line of duty as HR professionals, as people come into organizations, yes, the employment contract, we would require some of this information for payroll purposes, for onboarding and offboarding and all that. So yes, for purpose of entering into a contract or performance of the contract, that is one reason, or rather a ground for lawful processing. Another one is for compliance of any legal obligation which the data controller is subject. As a data controller, we had spoken about this, and what we mean by this is basically the person who is in charge of it, who has authority or to make decisions on this information. So an organization can be a data controller. And in terms of any legal obligation, this would mean one, making sure that you have you verified all the employees or customers of any way. So that's a legal obligation. So yes, you need to process this information. For that, compliance with just doing your due diligence. I know if you look into even financial sector and whatnot, they have anti-money laundering requirements in KYC. All these are legal obligations that need to be complied with, and yes, that becomes a reason for processing. Another one is in order to protect the vital interests of the data subjects or another natural person. A good and very capable example of protecting the vital interests is in terms of processing data relating to the different individuals for reasons of security. So yes, the security personnel at the door when they're taking in your information, or rather the security cameras, it's for the interest of the data subjects, for your own security. So it becomes a ground for lawful processing of personal data. Also for the performance of tasks carried out in the public interest. This ties in the vital interest. So if it's performance of anything for the public interest, then yes, it's a ground for lawful processing. For the performance of any task carried out by a public authority. That would mean any government authority processing our data for a reason of performing the functions, then yes. But I should stress that this should be for official functions and official reasons, nothing else other than that. For instance, you're going to collect your ID, your national ID. Yes, they need to process this information from your name, your date of birth, and everything. And that's performance of a public function. That's a good example. Also for the exercise of other functions of a public nature, the list can be endless, but I think it's self-explanatory. Again, for the legitimate interest pursued by the data controller or processor by a third party to whom the data is to be disclosed. This would, maybe an example is if you have a third party providing cybersecurity services or whatnot, then they may be allowed to process your data, or rather it becomes a lawful ground for processing your data. If it's for the interest, for instance, for them to protect your systems and your whole operations, it's in your legitimate interest, so that becomes a good ground. And maybe one other one can touch on is for the purpose of historical, statistical, journalistic, literature, and art or scientific research. This one, a huge part of it in terms of doing research or even journalism, the journalistic reasons, or even research papers in schools, all this information you're protecting to write a paper or to present something. Yes, it also amounts to grounds for lawful grounds for processing the personal data. So essentially, the list may be more than this, but this is just saying, in terms of processing, there has to be a very legitimate reason for processing this data. It's not, you're not allowed just to hold data for no reason at all. There has to be a ground for it. Another thing is processing of personal data shall be done in line with the purpose of its collection. We had mentioned this in terms of the purpose limitation principle, where you're only supposed to process data in line with the purpose of its collection, what you already expressly mentioned to the person you're collecting the information. Did you tell them you need this for onboarding requirements and you need to set up maybe some of the benefit schemes and the pension and whatnot? Yes, which should only be done with that for that purpose. Where you have another purpose that you wish to achieve, even if you already have that information in your custody, consent is very important. You go back and tell them, yes, we also want to undertake this and this with your information. Are you agreeable to this? That can be done in so many ways, even by email or by signature, any kind of way. And a data subject has a right to object to processing of the personal data. Basically, this means that even though they've given you the information, if you want to process for something else, they have the right to say, no, I'm not comfortable with this. Please do not use my data in that way or in that manner. That's one of their rights to processing. And unless the data controller processor demonstrates compelling legitimate interest or why you need to process this data, or for instance, if it's for establishment of a legal claim or defending a legal claim, unless you have been given explicit consent, then once a data subject has objected to such processing, or some manner of processing, that line should stop or cease. Category of processing is in terms of personal data. we had mentioned this before in terms of defining personal data, sensitive personal data, which we'd say that more, it's almost like seen as a higher level of personal data. You know, your personal data could be your name, your age. Sensitive personal data is like your blood group, your biometric. It's has a special category on its own. And that's why they're
Maurice, you're now breaking. You're breaking. I don't know whether it's the internet on your side. We keep losing you. You're breaking. Thank you. Can work on. Can you hear me, Maurice?
I can hear you. Can you hear me?
Yes, I can hear you. Now I can hear you. It will continue that. Thank you. Continue, please.
Okay. As we mentioned, sensitive personal data is a higher category of personal data, something that's even slightly more deeper than, you know, just your name. It could include biometrics or any other maybe processed one. The process is required is carried out legitimate activities with appropriate safeguards. So appropriate safeguards is something that's very key, and you'd also see it as a continuing theme, either in transfer of information, even now in processing of sensitive personal data. It's done on condition that the processing is done solely to persons who have regular contact with it in connection with its purpose. A really good example of this would be so yes, that's one of the grounds that you may legally be able to process it. You know, also to mention, making sure that consent is there as just a foundation. So the personal data is not disclosed outside without the consent of the data subject. Again, the aspects of privacy still prevail here in all. Secondly, by the public by the data, which is made public by the data subject. This would mean where they themselves disclose this sensitive personal data, then where they themselves disclose the personal data, then it's one ground where you can process. And also lastly, where, you know, this is almost some of the exceptions, where processing is necessary for establishing or defending a legal claim, or protecting vital interests, or carrying out very specific rights or obligations under contract or other of the specific person, for instance. So next, as we had spoken, we mentioned consent is a running theme in all areas of data protection. You need consent to undertake any form of processing, any form of transfer, anything. So the consent that we're referring here, you know, needs to be very open consent, very free consent. Nothing that can be challenged, you know. So by definition, it should be unequivocal, free, specific, informed. You know, those forwards are very you see in contracts, some of the signatures unequivocal, but they completely and fully unequivocally consent and agree to what the form of processing. Should be free, should not be under any duress or anything, and specific and informed. This refers to you inform them this is why we're processing, and they're okay with it and they're consenting to it. So this is what is actually deemed to be valid consent. When you're having any claim in terms of what's consent given, this is what's going to be looked as the foundation to deem that it has valid consent for the data processing to be undertaken. Just to note that a data controller and processor who bears the burden of proof for establishing and why. You as a data controller or processor now being asked now to utilize, because we're the ones processing this information. We are the ones, the custodians, we're holding it for organizations and all other entities. we are the ones who have the burden to prove consent was given, and this is it. Some form of evidence. Was it a document that was signed? Show it, look, they gave this, the one who consented. You are the one to prove, not the data subject themselves. And the data subject has the right to withdraw their consent at any time. Even if they already consented to the processing before, they have the right to say, to withdraw the consent and ask you to actually stop from it. As you can see, it just shows how much the act and the law, is really out here to protect the data subjects and their personal data and their rights and all that. So a lot of the obligations is for us as holding the information down, processing it, and controlling it. Was the obligation for a data impact assessment. Impact that may be foreseen for processing operations. What do I mean by that? It means it's an assessment of if you're having a new form of processing that would come up. For instance, if you're having a new way to store information in your organization and you will back it up in the cloud and whatnot. This is now where you undertake an assessment of that particular operation, or that particular storage, that particular uploading the cloud, to make sure that it has a low impact, or rather, at the best, no impact on the rights of personal data of the data subjects. This would mean make sure there are any safeguards and whatnot. But basically, where there's a high risk or to someone's rights in data protection, particularly our data subjects, our employees, our personnel, our staff, any member of the organization, even members of anyone participating here, your rights are required to be secure. And where there's any risk, or rather high risk, that they may be a potential breach or anything, then an assessment should be taken out. Maybe just going to the example, because it's something common we see. Usually we have new systems coming in every now and then, be it payroll, be it HR functions, whatever it is. Our day-to-day lives have been overtaken by technology, and we always have to include technology in everything. Meaning every time we're introducing something new, it needs to be something we're thinking about. Is it a high-risk impact? Is it something that has a likelihood of causing any disruption? If so, then yes, you're required to undertake an impact assessment to it. It's just something you should have in mind, if for any reason you're switching up the systems that you have in your organizations, make sure they're safe and secure, and that you have the right certifications for it. I would presume, most probably, if you introduce new systems where they have been built or developed internally, you'd have a higher likelihood of risk, and you'd more or less be required to undertake an impact assessment. This should be done actually 60 days before the date of processing. So if you're introducing a new platform for your organization that would be able to process and store information in XYZ for this and that reason, it should be done 60 days before you actually go live with it. What is contained in an impact assessment? So one, it just has a systemic description of the foreseen processing operations and the purposes for processing, including any legitimate interest pursued by the controller or processor. It just means have a description of the whole operation that you're undertaking and why you're undertaking. So if we have a whole new system that's supposed to handle productivity, for instance, in the office, or file management, or client management, or product management in any kind of way, one, have a description of it and what it's supposed to achieve. Is it supposed to help people manage things in XYZ? Is it a new system that will be able to store information across your different offices? Just be able to list that this is how it's done and this is the purpose. Two, has to have an assessment of the necessity and proportionality of the processing operations. This would just mean, for instance, you want to share information across your organization and you have multiple offices. It's something to think about, and you have to say why it's necessary and proportional, because there's no point of implementing a system that is usually used for processing information across the world, and you're just one office based in Kenya. That wouldn't make sense. So necessity and proportionality also should be assessed in the impact assessment report. Another is an assessment of the risks to the rights and freedom of the data subjects. Number one that comes to mind is risk of breach. Is it easily hacked, or is there any way that someone can access it that they shouldn't, or is there such information leaking? Is the information safe? Those are the questions in terms of assessing the risk. And also you should have measures to address the risks and the safeguards, security measures and mechanisms to ensure protection of personal data. So as you can see, basically, just in a nutshell, says this is the system and this is how it processes everything. Is it proportional, the necessity, what are the risks, and how these risks are addressed? That's the whole impact assessment in a nutshell. And just again to reiterate, this is usually done when you're having when you're thinking about introducing a new form of processing or operations, particularly in our digital world of today. Another aspect that's been introduced by our data protection law is an aspect of notification of breach. What does this mean? Now we are required, where there's a breach of information, to notify, one, the data commissioner, that's the regulator who's in charge of data protection in Kenya, and two, notify the data subject that there's a breach in writing. So an example of this, someone hacks our systems. That means you have 72 hours since you became aware of the breach. If you became aware of the breach, doesn't matter if it's been happening for the last month, as long as you're aware from the date you're aware of it, you have 72 hours to notify the data commissioner of the breach. And then you should notify the data controller, the data subject, almost immediately in writing. This could be by email or whatever. It could also just be a very general way, just saying, we've experienced, for instance, if your organization has been hacked or there's an issue in terms of security in the system, it's just putting a firm-wide email to say, we've noted that some of our, we have attacks on our systems and some of our information may be affected. We've noted that these are the files that have been affected and could include persons X to Y. That's just it. In terms of notifying the data commissioner, there's on the website of the data commissioner, they have a portal where you can report any breach and just notify them. And what you do is just log on, input the information, and as soon as you're done with it, you submit it. Then it's for the data commissioner to see if it's something worth investigating or not. Some of them, it's a mere accident, but for some people, if it's something that they think they would need further investigation, they will reach out and contact you for that. Retention of personal data. This, we had spoken about it in terms of one of the principles, and this is the principle of storage limitation. So it basically says that personal data should only be retained as long as may be reasonably necessary to satisfy the purpose which is processed. If you may recall, we had mentioned that you're not allowed to hold information beyond what it's needed for. With the example of you have employees, you have personnel, you have staff, you have contractors, all in an organization. At the point of onboarding and working with them to the point of offboarding them, then how long should you retain this information? Yes, there's no specific timeline, 10 days, 10 months, 1 year. There's no such timeline, but only what is reasonably necessary. For instance, if it's for tax claims and you're required to have it as law requires for something for almost about 6 years, then that's when you should have the information. But after that, you're not allowed to hold this information. Remember again, burden of proof rests on you. You're the one to justify when an issue arises. Why do you have that information? You're the one to say we needed it for X and Y purposes. It's even in our policies, we normally retain this information for this and that. If not, then you'd have a bit of a journey in terms of trying to explain why you're you're in breach of the law here. So some of the exceptions to retention to this principle of retention is one where it's required to authorize the law. That's what we had said. For instance, if if a law requires, I know some of the laws are very specific, especially in terms of records and accounts, of how long you're supposed to retain some information, some of bookkeeping and all that. Two, it's reasonably necessary for a lawful purpose. A lawful purpose being maybe a very general example for employment purposes, then yes, you should retain the information during that period. For authorized or consent, when it's authorized or consented by the data subject. Again, a good way to put this into your systems or into your, it would be through your policies. So one of the policies of the organization should have a retention policy where the employees are very aware that you retain the information for this and that reason and for this amount of time. And once they consent to it and they sign to it, then that's at least you're in the clear in terms of holding or processing personal information. And also for historical, statistical, journalistic, literature, and art research purposes, which I mentioned maybe for scholars or journalists and whatnot. We can now move to transfer of personal data outside Kenya. This was covered under the principle of non-transferability, where we said the rule of thumb is that you're not allowed to transfer personal data outside Kenya, with exceptions. One, where there's consent, and two, where there's appropriate safeguards. So there has to be proof of the adequate and appropriate safeguards in place, where this could mean proof that your security standards, or rather the security or the safety of the information when you're transferring is guaranteed. So how are you transferring? Are you just sending information in a in a Gmail file? There's a high likelihood that that's not secure enough. And that's not showing that you have adequate safeguards in place. But do you have a channel, maybe an online portal where you're transferring the information, it's being transferred for reason X and Y, then yes, then you may be allowed to transfer that information. So personal data may be transferred the data subject. One good example of both of these reasons in terms of performance of a contract would be where you have more than, or rather you have offices outside the country where you'd be required to allow such teams to be able to undertake your work. Or rather, even when you have offices outside and the head office is somewhere else that requires all this information to process and just manage all the information of their personnel and contractors. That could be one of the reasons for it. Also, in terms of matters of public interest being, how would I define it? Basically, anything that would be for the good of the public. If there's a reason for that in terms of transferring your data, then yes. Again, also for the establishment of a defense or a legal claim, that's also fair. Or where the data subject is physically or legally incapable of giving consent. So possibly maybe because of incapacity or them being a minor or whatnot. Or for the purposes of compelling legitimate interests, which are not overridden by the interests of the data subjects. This statement again emphasizes how the law is here to protect data subjects. So even if there's compelling legitimate interest, like a really good reason why this information should be transferred, it still should not have overridden the interest of the data subjects, because their interest comes first. Now we've covered the principles, what lawful processing means and how to undertake it, when you need assessments, when to notify, if there's any breach. All these were just some of the obligations and responsibilities that we bear. And just because that this is actually in law, all these responsibilities are in law, you're required to adhere to them. And where you don't, there's some penalties that accrue. For instance, we have general penalties of amounting to 3 million shillings or imprisonment of up to 10 years, where you're in breach of the Data Protection Act and data protection laws. Some specific penalties, some very specific offenses under the Data Protection Act come up with a fine of 5 million and imprisonment up to 2 years, or sometimes both. This is just to show that this is actually something that's very serious and people are taking it serious now. The government and regulators are looking into this, that data protection is now a thing. And as much as we as HR practitioners are very much involved or rather handle so much or large amounts of personal data. It's something to really align ourselves with, refresh our memories every now and then, be on the lookout.
Maurice, excuse Maurice.
Yes.
We keep losing. Can you go without video, please?
That's fine. I hope this is better. I hope this is better now. Right, as we were saying, there are now penalties when you're in breach of the Data Protection Act and the principles themselves. And as practitioners, we constantly more than interact with it. We process it on a daily basis. We're custodians of so much personal data. It would be best to have this at the front of our minds in everything that we do. In our storage of data, in how we handle it, who can see it, who cannot see it. It's just very prudent to always keep on top of it in case of anything. Yeah. Now, just to finalize, I know we had mentioned that aside from the Data Protection Act, we have a number of regulations that also came into effect that assist in enforcing the Data Protection Act and the principles themselves. So just provide further guidance and clarity in how X and Y enforcement, the duties of data controller or data processor, all of them, they just provided more in the regulations and registration requirements also. So I'll just leave this to my colleague, George, to take us through with it.
Okay, thank you so much, Maurice. So now discussing the data protection regulations, the most important point that we need to understand on the regulations themselves is that they are the procedural regime of the data protection law, of the Data Protection Act, and them being divided into three: the general regulations, the compliance and enforcement regulations, the registration of data controllers and data processors. With the general regulations, Maurice has discussed widely on them, so I will simply just skim through them. There is the rights of the data subject. What are the rights and obligations of the data subject? So when it comes to collection of the personal data, when it comes to the security of the personal data, when it comes to the processing of that personal data, in this instance, you need to look at it from that point of view. You need to look at it from how best is it going to further the ends of privacy of that personal data that has been collected. There is also the aspect of the duties of the data controller, the duties of the data processor. And as we had previously discussed, we mentioned that the data controller is the one who collects the data, and the data processor is the one who works on the data. That is just the simplest way I can put it. So what are the obligations of these individuals? Whereas one collects the personal data, how are they supposed to collect the personal data? Are they supposed to inform the data subject that they're collecting the personal data, and to what extent are they going to process that personal data? How are they going to use it? Because if you're going to take my information, be it for purposes of HR, be it maybe for purposes of transfer to another country, you have to inform me. So it is their obligation to inform the data subject. Also, for the data processor, when they are working on the data, they have to inform the data subject. They have to tell him or her that we intend to use your data for this specific purpose, be it for transfer, be it for purposes of processing of the payroll, be it that we are taking your personal data for the recruitment and selection process, whereby a data subject has applied to a specific organization for employment. You need to know, how will my personal data be used? Am I simply going to submit my credentials, my CV, my contact information, my academic certificates, and what's next? So you need to inform the data subject of what is going to happen to their personal data. There is also the point on the transferability which Maurice has discussed, and I will not delve too much into it. So that being the general aspect of those being the general regulations, which simply state what is required for the purpose of collection, processing, and controlling of personal data. When it comes to the compliance and enforcement regulations, the key thing we need to note here is, in the event there is a breach of personal data, where should the complaint be addressed? It is addressed at the Office of the Data Protection Commissioner, and you can file it either orally or you can file it by way of electronic means. It could be by web hosting, it could be by way of an email. So you simply send a complaint to the Data Protection Commissioner, stating that you have an issue. It could be breach my data. I forwarded my data to XYZ company, and I found it with another third party. So they are in breach of the Data Protection Act, and there is a complaint. There is a complaint mechanism, and there is also an enforcement mechanism. And we have already seen previously that there are penalties that accrue in respect to those penalties. There is the regulations on the registration of data controllers and the data processors. So, as we had previously discussed, there has to be a mechanism as to the registration process of the data controller and the data processor. Currently, the same commenced in the month of July, and it is done online at the ODPC portal, whereby you have to register both a data controller separately from the data processor. And there are instances where, and this is from my experience, we have seen that there are specific organizations or individuals who can be registered as data controllers, meaning they can only collect the personal data, and there are specific organizations or individuals who are also registered as data processors. So what does this mean? It means that for an organization, that depending on the volume of the work or the volume of the information that is carried out by an individual or an organization, it may be registered as a data controller only, or in other instances as a data controller and as a data processor. So each organization or individual has to understand what is the purpose of the information that they're collecting, what is the volume of the information that they're collecting, and also in some instances, what is the size of the organization. If it is an organization that has multiple companies outside the country, if it has various subsidiaries or various associate companies, then they ought to look into that. Yeah. So Maurice, from that I have discussed the data protection regulations. Perhaps you can proceed to the next slide. Yeah, Maurice, yeah, if I'm audible.
Yes, you are. Thank you so much,
Yeah.
George.
Okay. Yeah, thank you
for assisting with this.
Yes, I'll leave it to you. Thank you.
That was clear enough, and we are happy to take any questions that you may have. Maybe we can just start with the few that we have received so far. Rachel will read them to us.
Yes, thank you so much.
Excuse me, Maurice. Yes, you're not audible.
Thank you so much. Are you able to hear? Can you hear me?
Yes, Rachel, I can hear you.
Okay. We have several questions. Okay, and the first question is from Elizabeth Wangi. She's asking, is data registration compulsory for all companies? And where should we register? The other one, is there a threshold required to register?
Right. If I could just take that question. So there's a threshold for registration in terms of some companies or other entities that are required to register either as a processor or controller. And at the same time, there's there's some service industries that there's a mandatory requirement to register regardless of the threshold or whatnot. For instance, in the hospitality industry or financial services or in transport industry, they have mandatory requirement for registration regardless of the turnover of employees. So maybe based on your industry or maybe the size of the organization, we can be able to advise whether you need a registration or not. So we can do that by undertaking maybe an audit of your operations, and then can be able to advise further, even assist with the registration if need be.
Thank you so much for that. The other question is coming from Francisca Mweni. And first of all, she was asking, how do we conduct confidential reference? And also the second one maybe can come up with employee record. That employee record should be kept for 5 years. Do we strictly adhere to this, as most organizations keep files for a longer period? This is because a staff file is still alive even when the employee has left the organization.
Maybe I could just start with the latter. Yes, in terms of the data retention, or rather retention of employees' information, the requirement, as we've just discussed, is just retain the information for a reasonable amount of time. So in terms of what is reasonable will depend on why you need that information, what you're using for it. So I would assume or presume rather by saying 5 years, there's a reason why you could back it up and say, yes, we need 5 years because of this and this purposes and being able to hold this information for whatnot. Other than that, you're not allowed to keep the information where you have no reason for keeping it at all. So even for organizations who keep the information or store the information for much longer after the employee has left the organization, that is a potential problem coming up. You're not able to justify the reason why you're keeping this information.
Thank you so much. How then do we conduct confidential reference?
Maybe someone could just clarify what you mean by confidential reference. I can probably assist with that more.
Okay, there was also a question from Abed Lolokuru that can one person be a data controller and at the same time data processor? This also is coming from a question of can HR be both a data controller and also data processor?
So yes, a person can register both as a data controller and data processor. However, let me just make the distinction that it's the entity that's registering. So it's if you're a HR professional in that entity, it's the entity that's registering as a controller or as a processor or both, not you individually as the person. Because in terms of who's controlling the information, you're doing all that on behalf of the company. You're not doing it on your own initiative. So that's why it will be the entity that's registering as opposed to you as an individual. But yes, you can register as both a controller and processor.
Thank you very much. Says, how do we handle the information given therein, and if there would be employee demands for it?
Sorry, please clarify that.
That how do we handle the information given therein, and if there would be employee demands for it? I think this comes when the employee asks for their information back as a right.
Yes. So in terms of how you'd handle such requests, there should be maybe some procedures in place in terms of how an employee or is able to request to know what information you have, and in what form. Are they physical copies? Are they online copies, soft copies? There should be some procedures in place to be able to assure that, because it is a right of a data subject. So maybe something to just build it in, for instance, in your data protection policies, where you mention, for instance, if you require or want, or you have a request relating to information, email this and this persons will be responded to in probably in the 48 hours. Something of the sort, just something simple to show them there's an open channel if you want to exercise your rights. Doesn't need to be, possibly obtaining a whole platform or anything. It can be just as simple as that. So we could, make use of the data protection policies to include all this information.
Thank you so much for that clarification. We also have a question concerning principle number 8 from Irene Omune and other people, Terry Shiendu. They're all asking, what happens to multinationals who share data across different jurisdictions? How will they take care of this principle number 8? And maybe I can ask the other one, still on number 8, on principle 8. Like they said about the issue of not being allowed to send data outside Kenya. In most organizations, data is now stored on the cloud in various systems, in brackets box. And this is accessible even by our employees based in the US and others outside Kenya. How is this treated under this law? Also, the employee data we post on websites with staff photos and profiles. Please comment on this.
Okay. In terms of one, maybe I could just start with the one in relating to transferring information if you work for a multinational. If you may recall, the rule of thumb is that you're not allowed to transfer information. However, if you're supposed to transfer such information, one, there has to be consent and appropriate safeguards. So make sure the person onboarding are well aware that this, yes, I'm sure they're aware by person, but the contract or the privacy policy should be able to clearly state that you have different offices and you may be required to work maybe closely with persons in different offices. And with that, your information may be required to be shared. And that would be able to at least assist that of a multinational in being able to transfer such information. However, it's very important that in saying, or rather in putting it across that, we have offices in these countries, and in terms of performing your roles, you'll be required to liaise with them and whatnot. It's important that you list these countries, so you can say we have offices in countries X, Y, Z, just to be able to cover yourself and show that they have consented to the information being transferred for that specific reason. Security safeguards or appropriate safeguards just means make sure that your communication channels that are going to be used are secure, and there are other cyber systems also in place to be able to safeguard the information. And also, if it's in terms of, again, a multinational, I would assume it'll also form a part of the exceptions, where it's for the performance of the contract, either in the interest of the data subject or performing a particular function. Other than that, I don't think it would be an issue. Maybe the issue I can foresee is if you're not a multinational or you're just an individual and someone has asked you for information, then that's where problems can come in. I think the other one was in relation to
about the issue of not being allowed to send. This is accessible by employees based in the US. How is this treated under this law? Also, the employee data we post on website with staff photos and profiles.
Right. I remember there was also one regarding to how data is stored online and whatnot. Yes, I know a lot of data storage these days is online and cloud-based in a box of some sort, where servers are stored in different countries, possibly in Europe or the US or everywhere, especially with multinationals. In that case, again, the two basics, consent and appropriate safeguards, have to be there in one way or another. And then also depending on the nature of the volumes of information, if it's for the performance of a contract of vital interest, yes. If it's very sensitive and large volumes of information, then you might require a step further in terms of making sure you have the approval of the data commissioner. This is maybe an emerging trend that we see, where if persons are not able to align themselves with that, then they'd have to just store the information in Kenya, because maybe prior to the 2019 Act and its enforceability coming into play from 2021, 2022, there wasn't much oversight in it. But now, since there's a lot of oversight and the regulatory space is tightening, I presume you'd see a lot of changes in regard to this. So either aligning with the law or just refraining from storing data abroad.
Thank you so much. This is quite enlightening, considering that recently there was a newspaper article that came out and they were saying that there has to be a lot of tightening on the use of data, and it now should be taken with a lot of strict, and people should adhere to it, or else they will end up being in trouble. The other question coming up is that, can you give out employee data to a public authority when requested?
Yes, part of the processing, or rather the grounds for processing personal data, or the exceptions for the performance of a public function by a public authority, where a public authority or a governmental authority is asking for this information. One, there has to be a reason from it. I'd presume if there's an investigation launched against you or a company or against some individuals, there'll be evidence to it. So yes, sharing that information is not a breach of the law, because it's performance of a public function by a public body, and also for the public, that could also play in terms of the interest of the public or vital interest of the data subjects, if for the reasons dictate so. So that should not be an issue, unless it's not for any public function. Then yeah, you should not share the information.
Oh, thank you so much. The other question is from this an anonymous, is that, hi, this is great and timely for me, thank you. I have been working for this organization in HR department. I was recently moved to an open office accessed by anyone who has access to the organization any time of the day. I feel exposed, especially with personal staff files and other personal data I handle. I have complained and I've been told that I be locking the personal files cabinet, which as any human I may forget, and my desk is not lockable. How do I ensure my back is covered as a person from such an exposure? Thank you.
That's actually a very good question, because as mentioned, the wave of digital applications and being able to store everything online is what's actually now just sweeping across. However, there's still some entities, some persons who prefer, or rather just store the personal data physically, so they lock them somewhere, whatnot. Now, it becomes more and more of a risk and an issue because of the level of exposure that's opening up slowly. Before, maybe even if you go 10, 20, 30 years ago, that would be perfectly fine to lock them somewhere, because we didn't have phones with just cameras and come and take photos of information if you need and whatnot. But now it becomes a risk that's been posed. Possibly maybe one way to deal with it is find a way to store the data away from the sight of persons. If there's a cupboard, or if there's just somewhere you can physically lock them where only very limited persons have access, then yes, that would be very helpful. At the same time, it'll also be very prudent to continue pushing for a more secure system to be able to store this information, especially if you keep holding large amounts, large volumes of data. You really need something above just a lock and key for that.
Oh, thank you so much. That is great. I think we are still having so many coming in. The other one comes in from Dhangani Muya, is saying, can data privacy breach amount to defamation, libel? And who should be, he's also still asking about who should be appointed a data controller and processor. And he's giving examples, but I think we had answered that.
Right. In terms of whether a data breach can amount to a libel or defamation.
I think it comes to definition of what is defamation.
Yeah,
Is the information true? Is it false?
exactly. You know, we're talking about data breach. We're talking about someone getting unauthorized access to personal information, which is separate from defamation, where you're claiming information, false information about you has been spread. You know, it may not because of what these two, actions would entail. So I don't think it would amount to it unless the no, those are two separate claims. You have them.
Okay, thank you so much.
Yes, Rachel.
Yes, please.
Yes, if you'd allow me to add on that. Okay. Regarding the question, defamation and data protection are two different areas of law. In defamation, whereas you're referring to misinformation that has been passed on to a third party and it has caused injury to you, the remedy for defamation, you can only seek it in a court of law. But in the event there is a data breach or there is an offense that has been committed under the Data Protection Act, then that complaint ought to be filed by the Data Protection Commissioner, and the remedies will also be provided that have been provided for under the Act will only be subject to the Data Protection Act. So those are two very, very distinct areas of practice. Yeah, that's my addition. Thank you.
Thank you so much, George, for that. The other question is, so what happens when a data subject asks to withdraw their consent, but an action has already been taken following the initial consent?
So one of the rights that we've discussed is that they have the right to object to the processing. And yes, they might have already given the consent for the processing, and you might have already begun. But what is required is as soon as they object it or withdraw, at that point, then you stop processing it in whichever way. If you already process it before, that's fine, and that's legal. But at the point where they object to it, for instance, they send an email and say, right now, stop this form of processing, that would mean at this specific time going forward, you should not. And anything after that, you will be held liable and accountable for it.
Thank you so much. The other one from Mr. Abed Lolokuru is like, if a breach happens and is resolved eternally, do you still have to notify the commissioner?
Well, yes, you still have to notify the commissioner in case of the breach. Because in particular, it's in regard to safeguarding the data subject. So you still need to notify the commissioner, and you also need to notify the data subject themselves that, yes, there was a breach and your information was affected. So you still need to notify both.
Thank you so much. This is quite enlightening for us. We still have so many questions coming in. Milka, maybe you can help. Or should we still continue answering them? There was one saying, we still leave our ID copies or telephone numbers in the entrances of some offices. Is this not a breach of DPA? Someone also asked a similar thing and said what if the people are using this information at the entrances to commit for example, IDs to commit crimes, are being used for criminal activities? How are we covered? How are we protected from this?
Right. I think in that instance, one of the grounds for lawful processing was, to protect the vital interest of the data subjects. So if you remember me mentioning, in regards to security officers or personnel taking copies of IDs or anything, it should be strictly for security because it's protecting your vital interests. However, them using that information for anything else is still in breach. But also whether they're using it for a crime or anything is still very much against data protection. And also it's something that should be taken up by the organization themselves who put the officers there. They should be able to either have a policy or communication, just letting people know we have security for this purpose. So that even by the time they're taking the information, it's still in your interest and you more or less are aware of what's going on with it, and that should only be what the information to be used for. Yeah.
Thank you so much. I think this also brings us to this enlightenment that at all times the policies have to be set and people need to be made aware about what their information is going to be used for. Even when they are registering their information somewhere, it has to be above, maybe written somewhere. This information is specifically for this and that purpose, especially with now that the law has come up. Okay, another one. The above one. See, for example, how about there was someone who was asking about the access and abuse, that someone finds out where you live and stay or your marital status and uses that information to push their selfish agendas other than the official purpose. Or maybe also when they find out your sickness, what you're suffering from, or what if you're having, as HR professional.
Yeah, that is very much in breach of the Data Protection Act, because the only form of processing that's allowed is where you're expressly aware of the purpose and use of that information, and then you consent to it. So where officers abuse that right and take the information, use it for anything else, that is against data protection, and yes, can bring an action against them for it, because that's not what you had consented to. They can only use it for the specific channels you had allowed them to.
Thank you so much. How about this one? I don't know if we had asked it. How do we ensure compliance with data protection law or act where recruitment is concerned, more so on reference check and past employer? Did we ask that?
No, but in terms of onboarding personnel and whatnot at the reference checks, I would presume that even while people are making applications on everything, that there should be either a link to a private policy where they are able to see, and in the private policy, it has a section on when you're submitting application and where it tells them exactly what you're going to use the information for, and even including you at least disclosing that you will reach out to their references and say why you're reaching out to seek information about their capabilities and employment history. As long as that's very well reflected even throughout the recruitment and onboarding process, and that should be fine.
Thank you so much. So it's really important to have a data protection privacy policy, a data protection policy that is signed before most of the time, or consented to before someone can access a website, or even before they can begin giving you information. It helps us to cover ourselves. Is there a process of changing the appointed, what is the process of changing the appointment of data controller process, assuming that the company decides to appoint a different person?
Right, maybe just to clarify from the question itself, the company does not appoint a data controller or processor.
Right.
The company is a data controller or processor. So by the mere fact that you are controlling or processing this information, you are the processor controller. So you're not appointing anyone, it's you. So if you just have to register, and until you maybe stop with the processing or handling such information, I'm not seeing any sense why you're going to change that. And unless maybe you're referring to changing or rather replacing the data protection officer in the company, who is just someone appointed to ensure compliance in terms of processing activities. That's more of an employment issue. If you're not happy with the person, you can go through your what's called employment procedures, either terminate or recruit.
Okay, this one was maybe a follow-up question on one of them, that how is this legal audit carried out, for example, in this matter?
Right. So a legal audit is just it may be in a nutshell, it's just undertaken A to Z review of the whole company's operations. Just seeing this is from how you collect information, what the processes that that's undertaken, any form of processing, what happens, how it's stored, who sees it, who uses it, where is it taken to, is it transferred, all that, just doing an A to Z of the company, being able to note if there are any loopholes or anything, and then undertaking compliance structures and measures. So for instance, you find, yes, there's a loophole here and there, now recommending measures to be able to avoid that. So that's basically an audit now.
Thank you so much. I think we maybe the last person, Victoria, is conducting background check of a potential candidate here, a breach of DP. I think we had already answered that. So what is the first, the other one is, so what is the first step towards compliance?
All right, that's actually a good question. I think maybe just what we mentioned, first step of compliance is identifying where you need, where there's issues and whatnot. And that comes through undertaking a legal audit. So just do a data protection audit where you go through the XZ of the company and seeing, okay, maybe we're exposed here and there, and then trying to undertake compliance measures to align it to the law.
Thank you so much. Over to you, Melka. I think we've answered basically most of the questions without, even the ones that are repetitive, we've given them and summed them to one question. Thank you.
Wow, thank you so much. Thank you so much, Maurice and George, and also Rachel for the good job. You've really nailed it. You'll agree with me, participants, that this is one of the most exciting session that we've had. Asanteni sana. One of my takeaways, actually, when we're going through this, that HR now has to come up with a new manual, HR manual. This manual should be aligned with the data protection. That means we have to redo our HR manuals. So that's to remind you that the Institute is as scheduled for a training on workplace policies, 21st to 25th. You should not miss this. So you should attend for you to learn how to align that with the data protection with your policy. So thank you so much. Thank you, members. Thank you for this. I've really learned a lot. At one point, actually, I interrupted and I was told that it was on my side. I decided now to keep up, thanks to members who alerted me on WhatsApp. I kept saying, no, Boris, we can't hear you. Can you do this? Little did I know that it was on my side. So thanks to members for alerting me on WhatsApp that it was on my side. The rest were okay with the session. So thank you so much, Maurice and George. And also, I'd like to take this opportunity to thank our participants. Without your participation, this webinar would have not been this successful. And also to thank our Executive Director, CHRP Kuresha, for allowing us to partner with Nutrition International. Just to update you on our coming events, we have a conference coming up next week in Naivasha at Sawela Lodges, 25th to 28th. You are all invited. Please don't miss. It's gonna be lit next week, 25th to 28th. Then you also have HR for non-HR professionals coming up in November. This one targets your procurement, finance people. Yes, they should also learn HR. At least for line managers, those who are not HR, but if you're HR, you also want to attend, is okay. So all are invited. This will take place in November 7th to 11th in Mombasa. We have Kenya Labor Laws coming up in Nairobi, 21st to 25th. We have leadership. Actually, we're going to Turkey in November. You should not miss this. We also have, as I mentioned earlier, workplace policies and procedures, November 25th to 22nd to 25th in Mombasa. You're all invited. And also executive public speaking. November. This November is packed with a lot of events. We also have certified employees relations. It's also happening November 28th to December 2nd. Then we'll close it with the HR Dinner Awards, communication to follow. So thank you so much. I don't know whether my director is still around, but if you can say something to members before we close.
Yes,
Edie, are you there? Thank you so much.
Yes, I am right here. Thank you so much, participant. I think this has been one of the most engaging programs I've seen. We've remained 400 plus and all. So asanteni sana to our moderators, facilitators, Wow, thank you. Allow me at this point, I think Net Sharia has done a very, very great job for the last 2 hours. And one of the partners will just tell you quickly what they do and how you can reach them out. Karibuni Net Sharia.
Good morning, everyone. Can you hear me?
Yes. Yes, I can
good
hear
morning.
you.
My name is Njomo Kamau. Thank you, Koresha, and the IHR team, Milka, Irene, and all the team who have supported us and helped us in setting up this webinar. I also want to take the chance to thank my Nigeria team of Maurice and George and Rachel, who have taken you through this presentation very, very, very well and concisely. And to everyone who has attended, to taking the time this morning to listen to us. My name is, as I said, Njomo Kamau. I'm the director at Net Sharia. Net Sharia is an online legal portal, basically targeting provision of legal services online to entrepreneurs, artists, entertainers, and basically startups of all forms. And we do that through various ways. We have access to legal documents on our website, www.netsharia.com, where you can log in and go and access the legal documents that you require and that are fitted to your general needs, business needs. So they range from all sorts of areas such as company incorporation, company management, day-to-day operations, capital structuring and raising, intellectual property, including corporate and trademarks. So basically any documents and agreements that you may require for your daily business needs. We also have a legal consultation portal element where you can then sign on and then you get access to the range of lawyers available in Nigeria to then guide you on the various legal topics that you may require. And then you may then select the various timelines you may require, whether you need 15 minutes, 30 minutes, or 45 minutes or an hour. And those are billed according to the time that you spend. The third element, and one which you might be very interested in, is the legal retainer model through our entrepreneur club. So the entrepreneur club basically gives you a whole range of legal services, ranging from property all the way to company secretarial, again to company registration. The idea here being that it is understood that you being in business come across various legal requirements from time to time. So instead of then charging you on a case-by-case basis, except for specific matters, say for example, litigation, which have their own charging mechanisms, we are able to give you a retainer service for specific legal services across a wide array of your business needs. So therefore, when you then look at the range of services provided, we're able to sit with you and then agree a retainer model that can be paid, on a monthly, bi-monthly, quarterly, or annual basis, depending on your needs and on your size and your turnover. So we welcome you to review our site again, www.netsharia.com. You can also write to us on info@netsharia.com, where we'll be able to then address your needs. If you want to then have a one-on-one with us and tell us your specific needs, we're able to then to come up with a specific business model for you. So with those few words, I just want to say thank you again. We look forward to meeting with you and to engaging with you. And thank you again to IHRM for having facilitated this, and to everyone who has attended. Thank you.
Thank you so much, Edie. Thank you so much, Mr. Njomo. It was good partnering with Nigeria, and we are so happy. I believe delegates, participants are also
Sorry,
happy.
I just want to put my video so they can see me.
This
is not Maurice. This is
yes.
I was talking.
Actually, I'm also seeing you for the first time.
I think we've talked a lot and we've not seen each other, so it's a pleasure to see you. Yeah, and
I'm seeing you for the first time.
Yes. Thank you for support and assistance. Yes, thank you.
Okay. Thank you so much. Thank you, everyone. Thank you. Have a lovely afternoon. Yes.
Okay.
Bye,
Thank you.
everyone.
Bye-bye.
Thank you. Bye, everyone. Have a good
Bye.
afternoon. Well done, guys.